Good evening. We are here live from Houston, Texas. Every week we're bringing immigration updates. Today we're going to discuss about Senate immigration. Where is it right now, immigration bill? Is it in the Parliamentarian or is it with the Senate? We're going to discuss about that. We're going to discuss about if you have an adjustment of status EAD and you have an H-1B, should you let your H-1B go or should you maintain both of those things? We're going to discuss about that. We're also going to discuss about once you get the green card approved under the employment based, what can you do, what cannot you do? Emily, now we have the provisions of the immigration bill in the House, and it clearly mentions the provisions, employment-based provisions. Especially they said they're not going to count the family members. That's a very good thing. They're going to give back the unused green cards from 1992 to 2003, and there's a possibility for more. So that's approximately 250,000 extra green cards. They said that if your priority date is more than 2 years, you can file the adjustment of status by paying extra $5,000. Which most of our people will be fine in paying that extra $5,000. All these provisions are good, the best that we can advocate under the current circumstances. I don't see the per country quota off. It still exists even after this one, and these provisions expire after 10 years. So irrespective of this is a good bargain for us. The House bill has it. But what's going on in Senate? I mean, we have the House and we have the Senate. For the people who don't understand House and Senate, House is the lower house, what in some of the countries call as a House of Commons in England. In India, it's called as Lok Sabha. And then we have House of Lords in England, and India we call as Rajya Sabha. Here we call it as a Senate. What's going on in the Senate, Emily? Where is the bill in the Senate? What immigration provisions are there?
Right. Well, in the Senate, everything was kind of on hold because we had a couple of Democratic senator holdouts that didn't like the total amount of this reconciliation bill. So last week they came to a final agreement on a reduced number. So that's a good sign that we're moving forward with reconciliation. But what's in the reconciliation from an immigration standpoint, that's back to the Parliamentarian. So we're now on to Plan C.
Isn't the same lady, Elizabeth, who used to deport immigrants?
Right. Yes. So now Plan C, still unclear whether it's been provided to her today or still in the progress of being provided. I don't know what takes so long of providing. We've known what Plan C is for 2 weeks now. But it's back in her court or will be very shortly. And Plan C is some sort of protected status for the undocumented dreamer kids, not a path to citizenship, nothing long-term, and waiting to see if she agrees that that is something that can be done through reconciliation. If she does agree, then the Senate will finally actually write a bill, and then we'll be able to see what the actual language is and whether it includes the employment-based provisions, because it sounds like still, there's no plan on providing those provisions to the Parliamentarian. They're just focusing on this one little thing at a time, and then later they will add in all of the employment-based provisions when they actually write the bill. That's the hope.
So at this point of time, we don't have a clear guidelines on the Senate bill whether the immigration provisions are presented to the Parliamentarian, whether they're going to be there in there. Assuming that the way that she has refused 2 times though, and the House passes a bill which has the immigration provision, and the Senate passes a bill which doesn't have the immigration provisions, what will happen then?
Yeah, so then they're going to have to conference between the House and the Senate and come up with a compromise bill that may or may not include immigration provisions.
What do you suggest our audiences to do? Of course, everybody wants the House bill to be in there. The immigration provisions should be in there. They are part of the economy. They should be. What do you suggest them?
Yeah, I think, we definitely want those provisions to stay in the House bill. The House, sounds like they're planning on voting on their new version of the bill this week. So you can contact your congressman in the House and let them know you appreciate them voting for keeping those employment-based reforms in the bill. And then you need to contact your senator to make sure that they include employment-based immigration reforms in whatever final bill happens to be passed.
Emily, for the audiences, we have provided a link for you to contact your senator and the congressman. We have provided a draft copy of the letter that you may want to use it to write to explain to your senators in the House, so that senators and also to the House representatives, so that these provisions of the immigration bill should be given importance. Please, if you have not already written, please write to the House, to your representative and also to your senator. Emily, now we have people who filed adjustment of status in October of 2020. A lot of people have got their employment authorization. A lot of people are about to get their employment authorization. A lot of them have this H-1B. So let's discuss about, should they keep the H-1B, or should they let the H-1B go and go on the adjustment of status? Can you explain, Emily, what are the advantages if they let H-1B go? Let's discuss about it, Manan.
Sure. Yeah, I think one of them with the EAD is more flexibility in changing jobs, changing locations, changing employers. The EAD is not employer specific like the H-1B is, and it's not tied to a specific job. Now, you do have to have a valid job offer for permanent employment that's similar to what you were originally sponsored for, but you have more flexibility in working on that EAD. So if you wanted to change employers, what do you need to do? Do you have to tell USCIS that you're releasing your H-1B, or?
No, you just have to use the EAD, Emily. And if you're changing the job, they can file a 485J supplement that allows them to move to different company. They don't have to get the receipt notice to them. They can start working before they even file the 485J supplement. They can file it. They can start working on it, and the process is very easier. The filing fees is zero, and especially if they're moving from one location to another location, also, Emily, on the EAD, they don't need to notify the USCIS, unlike the H-1B where they have to file an amendment. Here they don't need to. When they file a change of employer, they have to file the filing fees, end client letter, vendor letter. All those are not required when they file the 485J. Also, if you use the EAD and let your H-1B go, you don't have to have a stamping when you go to India or any of your country, though. You just have the advance parole. You can use the advance parole for you to travel. That will avoid you to going for stamping if you use the EAD. Emily, how much it costs for these people to extend the EAD and advance parole?
Yeah, that's another great advantage. There's no filing fees for it. So if you choose to use an attorney, you would just be paying the attorney legal fees, but no filing fees compared to an H-1B extension or transfer. With those filing fees can be in the thousands of dollars.
And if you want to do an additional job on EAD or a side business on EAD, you don't have to file anything. You can just start using your EAD, do the additional job or a side business or side working. You can do that. You can do 2 jobs on the EAD. You don't have to notify anybody if you do so. So these definitely are advantages of it, though.
What about H-4 EADs?
That's a good point. If you are an H-4 EAD, the extensions are taking a long time. When it comes to the adjustment of status EAD, the advantage, Emily, is that once you file the extension, they can continue working even after the EAD expires for a period of 6 months. I mean, they don't have to wait for the EAD approval. You can file the adjustment of status EAD extension within 180 days before it expires, and you can continue working. Unlike the H-4 EAD, once the EAD expires, you cannot work. But the adjustment of status EAD, you can continue working after you EAD expires. Emily, what about the FDNS visits? So do they have FDNS visits that commonly happen for the people who are in EAD, or what's the difference between that and EAD and H-1B?
Right. No, there's no site visits for EAD applications. So the site visit program, the FDNS fraud detection, that's all related to the H-1B. So if you've been filing H-1B transfers and extensions, you may have gotten a site visit over the years. Once you move to the EAD, there are no site visits for that status.
How extensive is the process of filing an EAD and advance parole? What are the documents required?
Yeah, it's quite simple compared to an H-1B. You don't have to get an LCA. It's a matter of showing that you have the I-140, either the receipt or the approval. The adjustment of status is pending, so you have your 485 receipt, And then you have your passport and proof of lawful entry last time, your I-94. And if you are filing as a dependent, then your marriage certificate or birth certificate for the children. And that's it compared to an H-1B, which is education documents and end client letters and pay stubs and all of that.
What are the cons of going on EAD, Emily? Are there any cons?
There are. So one of the benefits of H-1B extensions is that once it's filed, you get automatic work authorization for up to 240 days after your H-1B expires, whereas the AOS EAD, that automatic extension is only 180 days. Now, hopefully you would get the new EAD within that 180-day window, but with current processing times, there are some people that don't. So an H-1B does have that added time period for the extension to be pending. What about the time period that you get the approval for the EAD versus the H-1B?
EAD and advanced parole under the new administration will be approved for 2 years, but H-1B, you will have an advantage of 3 years of H-1B approval. Emily, what about in the time period when the advanced parole is pending? Can you travel when it expired though? I know that you told that if the EAD, adjustment of the EAD is pending, extension is pending, they can work up to a period of 180 days. What about the travel though?
Yeah, the advanced parole is not automatically extended. So if you filed your renewal and your current advanced parole has expired, you can't use that receipt notice of the renewal to travel. So you may be stuck without being able to travel until you receive that new advanced parole. And also, what about, if the main applicant uses the EAD, what happens to the H-4 dependents? Can they continue H-4?
No, they cannot continue on H-4 EAD. They'll have to be using the adjustment of status EAD. Now, if the dependent uses the EAD though, the adjustment of status EAD, the main applicant can still continue on the H-1B. But if the main applicant uses the adjustment of status EAD, the dependent is forced to use the adjustment of status EAD. What about if they decide to refile the 485 application, Emily, and they use the EAD, can they do it?
No. So in order to file a second adjustment of status application, you have to be continuing to maintain a non-immigrant status up to the time of filing the second application. So if you've used the EAD and are no longer in your non-immigrant status, you cannot file a second application.
What about there are circumstances where the I-140 gets denied or the 485 gets denied? What will happen if they move to the EAD?
Yeah, once the 485 is denied, you no longer, if you've moved to the EAD and have not kept your H-1B or H-4 status, you're immediately out of status. You don't have anything to fall back on, and you immediately start accruing unlawful presence. It's very difficult to get back into proper status without leaving the country in that situation. So I think a lot of people keep the non-immigrant status more as just a backup plan in case something goes wrong with the adjustment of status. But at the same time, what are the likelihood that something is going to go wrong? I mean, usually once the I-140 is approved, that's the biggest hurdle. The 485 getting denied, we don't see that happen very often in employment-based.
There are both pros and cons in maintaining the adjustment, in maintaining the H-1B. I see more cons, Emily, because it's a big burden to maintain the H-1B. You have to go to stamping, you have to file the extensions with a lot of paperwork, a lot of money is involved in it every time. You change the location, you have a burden of amending it, you have the FDNS visits. There's definitely those kind of cons are there if you maintain the H-1B. There are advantages in EAD. There are also some cons in there are some advantages also in maintaining the H-1B, is that you have the flexibility of travel a little bit more than the advanced parole is pending. And if there is an I-140 and 485 gets denied under any circumstances, so normally I do not recommend people whose I-140 is not approved to go on to the EAD. I tell them to wait until the I-140 is approved though. But it's up to each individual choice what they do. I personally, when I was in adjustment of status assembly, we let our status go. We moved on to the EAD. We did not extend the H-1B. I personally did not extend the H-4 myself when I was having an EAD, because first thing I wanted to work. There was no EAD at that point of time for the H4, so I had to work. I was an immigration lawyer on the adjustment of status EAD. I've attended many interviews on the 485 as a lawyer on the EAD myself. So I'm an advocate of an EAD as compared to, because I'm a product of that. I was a lawyer when immigration, while going to the immigration, attending the interviews on the adjustment of status EAD as a lawyer. So I'm an advocate, but it's up to each individual situation. What you want to do it, that's up to you. But these are the pros and cons that we feel are that you need to know. Anything else, Emily, before we move on?
I think we can move on.
Emily, a lot of people are paranoid that once they get the green card, they're paying me consultation fees just to ask one question. Can I switch the job? Once they get the green card.
Yeah, I think there's a lot of myth out there. The 6-month rule, I don't know. There is no 6-month rule. And I think there are, let me say, a lot of attorneys in general, our job is to advise people of risks of a certain action so you can make an informed decision. So I think a lot of attorneys will advise people that, well, technically, yes, you can change jobs, but there's a risk. They could come back and question your intention and that sort of thing.
Have you seen in your career, you've been working in immigration field only, you never worked in any other field. Have you seen any green card getting revoked because they stopped working for the company that got the green card, Emily,
Never.
as soon as they get the green card?
Never.
Have you seen any citizenship getting denied because they stopped working for the company that got them the green card as soon as they got the green card?
Never.
What is this provision? What it says that there's a memo of the USCIS. It says, should the USCIS deny the 485 application if the person has never worked for the company that filed an I-140? What does the USCIS say on that, Emily?
It says no, you should not deny simply because they've left the employment before you get the green card. So if USCIS allows you to leave that employer before you even get the green card, why would they not allow you to leave that employer after you get the green card?
The AC20, the laws before AC21, Emily, were different. That law became law in 2020, 2021. It was quite different, though. That 180 days provision was not there at all. That was created. So all these myths, I think so, were been written by the lawyers who have been practicing way before. I mean, like old lawyers like me. But there's a lot of change. I mean, after that, it's very clear that people can change the job. People don't have to join the job at all for the sponsored companies for which they got sponsored. It is only the intention of the company to take the employee in. It is the intention of the employee to join. But if they change their opinion, it won't matter. That's fine. I mean, how many times have you, Emily, promised on the January 1st that you're going to do it? You didn't do the activities. Yes, those kind of New Year provisions kind of thing, you fail to complete it. I mean, nobody's going to come and shoot you down because you didn't run 6 miles a day, which you promised on January 1st. I know you do. It's a similar fashion, though. It's the intention at the time when you're making the application. But if you don't follow through, you change your opinion. We haven't seen, in my practice, I've never seen any green card getting revoked. I haven't seen any citizenship getting denied. So I don't see why they cannot change. They should be able to change. Let's go to the question and answers. For those people who are new to this one, please like our channel and give us some messages how we can improve serving you better. Let's go to question and answers.
All right. Raghu filed an H-1B, H-4, and EAD extension all together. The H-1B, of course, got approved. H-4 and EAD still pending forever. And now he's planning on changing his project, and his employer has to file an H-1B amendment and wants to know how will that impact the pending H-4 and pending EAD application. Generally, there would not be any impact at all as long as you are maintaining H-1B status. Your spouse is eligible for the H-4 and H-4 EAD. Now, if that amendment were to be denied, maybe I would send in an explanation or something for the pending H-4 and EAD to show how you've maintained your H-1 status after that denial, but the filing of the amendment should not have any impact.
Deepak from YouTube has this question. My kid's I-94 has expired in September. They did not file the extension. What effects will the kid have on the H4 visa? Deepak, since it's a 5-year-old child, you can file a H4 right now, even though I-94 expired. It's called non-protect. That means just please excuse me for being for not filing the H4 extension proper timing. It is not my mistake. It's somebody else's mistake. The kid can file the H4 extension. Typically, 5-year-old kid, come on, he could not know the things. They do give the extensions normally. And if by any chance for the 5-year-old kid, if they don't give the extension also, the damage is not that bad. The children under 18 do not accumulate the unlawful presence. So it will not have any negative impact in the short term. It will not have any negative impact on the long term. Now, Deepak, if it was your wife whose I-94 expired, you did not file the extension on the proper timing, I would have told you stop right now, contact a lawyer. But since it's a 5-year-old kid, the negativity that you are going to get it on the short term and the long term for the kid is very less or none at all. So file a H4 extension, delayed H4 extension. It's okay.
Sai wants to know, is public charge still in place? Does USCIS check the credit score, and what's an acceptable score? So public charge is still in place. It's always been in place. What's different is the Trump administration changed how we look at public charge. So they're the ones that created that 944 form, required you to submit your credit score and all of those sorts of things. All of Trump's changes to public charge are gone. You no longer have to submit the I-944 form. You don't have to submit a credit report or credit score or any of those financial documents or health insurance documents. So we're back to how it was prior to Trump, where generally being an employment-based, having a valid job offer is enough to show that you won't be a public charge.
Praful has this question, is any bill that is telling the administration to process the 485 process soon? Yeah, they definitely are allocating more budget to the USCIS. It may definitely expedite the process. But Praful, we personally don't believe it's the money that is delaying it. It's the administration hurdles that they have put among themselves that is delaying. For example, as Emily has just pointed out, the 944 application just delayed the entire process. They have simplified a little bit. They still need to simplify a lot more than what they are doing to get it. They need to eliminate the 485 interviews for the employment based, which didn't used to be there before 2017. So if they implement those kind of provisions, so things can be simplified. So there is a bill that allocating budget, but the administration can still do much better than what they are doing. Especially, we don't want the 140,000 extra green cards that we are getting to be wasted. I do recommend, Praful, that you need to write a letter to your congressman, because under the current provisions, they can still simplify, get this process rolling faster. We have drafted a letter. We have given it to you at the link. Please write a letter if you have not written it already.
Amit has a 2012 priority date, EAD and AP approved, 485J receipt, already submitted medical and birth certificate in response to an RFE, and wants to know what are the options and precautions to do a job change at this point. So I'm assuming your I-140 is already approved, and I'm assuming your 485 has been pending for 180 days. So that makes you eligible for AC-21. So a job change can be as simple as using your EAD to start working for the new employer and making sure the new employer's position is similar. It doesn't have to be exactly the same. It can be a different title, salary can be different, work location can be different. As long as it's in a similar occupation, and the new employer just needs to submit a 485J supplement that you sign and the company signs. That should be all you need in order to change jobs at this point.
Emily, I want your attention on these things, and this is something that's going on. People have earned a lot of money in the cryptocurrencies right now, and they want to do the EB5, especially Jiggies, and I don't know where, but there are a couple of people who are posting that, with cryptocurrencies, they made tons of money now. Do you advise people moving from adjustment of status EB3 to an EB5?
Well, one thing to know is you cannot port the priority date of your EB3 into an EB5. So you're starting from day 0 when you file that. Other things to know about EB5, the regional center option with the lower limit of your investment is not currently available. So you'd have to do the $1 million investment. And the processing time of that first step is 3 to 4 years right now.
Well,
and it
I want
does
to correct
not,
yourself, Emily. 3 to 5 years.
3 to 5 years, and it does not provide you with any status or work authorization while it's pending. Let's say that works out for you and get that approved faster than maybe your employment-based EB3 adjustment of status goes through. Remember that green card that you get to, once you get that first step approved, only then can you file the 485. You have to make sure a green card is available. So there are still some times when EB5 retrogresses and
Let's
you can't
assume
file.
even that is current.
So assuming the EB5 is current and you file that 485 and you finally get that green card, it's only a 2-year green card. It's conditional. What? It's not a permanent green card. 2 years later, you have to file another application to remove the conditions. That processing time is another 3 to 5 years. And there's no guarantees that you'll be approved and receive a permanent green card at the end of it. A lot of people get the first one approved, but not the removal of the conditions.
How much is the whole time process from zero to get a green card?
I think it's 10 years when you add all
at
of
a minimum
up.
of 7 years to 10 years is a time for EB5. In fact, what we normally do is for the people who file in EB5 and they maintain the non-immigrant status, we are filing the adjustment of status under EB3 and EB2, and we are withdrawing the EB5 adjustment of status though. The reason is that we don't want them to get the EB5 green card because that green card is only valid for 2 years. After all that money that you spend on it, you only get green card for 2 years. And then you have to remove the conditions though. So people who are contemplating and moving to EB3s, EB2s to EB5 need to know the reality that it may take 7 to 10 years if everything works okay. And a lot of times you lose the money and you won't even get the green card. We have seen, I mean, when I go to this Indian functions, Emily, I mean, these kind of events though, I see these little kids handing around, you'll get an EAD within 3 months. Is that true?
No, definitely not.
So please contact an independent lawyer though, rather than actually the people who represent these particular organizations that mislead though. Contact an independent lawyer before you embark into the journey of EB5. It's not an easy one. It involves a lot of money and there's a lot of uncertainties in there. It's not like you just throw the money, you get an EAD or green card. That's not that easy at all.
Love to Learn has a pending 485 about to receive that EAD and wants to set up a new business. The new job will be similar in this business to what the job was on the I-140. Are there any issues with the green card process? So AC-21 does allow self-employment as a way for you to port. So assuming your 485 has been pending for 180 days and assuming your I-140 is approved, you can port to self-employment, and your new employer, which is your new LLC business, can fill out a new Supplement J form and submit that so that your process can continue with that new company.
Do Indians from South Africa qualify? I don't know what you mean, but first thing, Ravin, that you need to specify is that are you born in South Africa though? If you're born in South Africa for the purpose of the green card, you will be considered to be a South African for the purpose of the green card. So I need to know where you're born at. If you're born in India and you got the South African nationality though, for the purpose of the green card, you will be considered as Indian forever.
Srikant says, if I use my EAD, but my family is still waiting for their EAD, will they lose the status? Yes. So they will then be in adjustment of status. They'll lose their non-immigrant status if you, as the main applicant, stop using your non-immigrant status and use the EAD, and they would not be able to work until they receive their EAD.
My son, Manoj, my son age is locked out, EB3, EAD and current, I-140 approved. Should I file an EB2 application? Oh, that's very dangerous. Because if you're filing an EB2, we need to look into if you're going to qualify, if your son is going to be still qualified for it or not. So I would recommend that you contact a lawyer before you file an EB2.
Idra says, thank you both of you, followed your timely guidance and advice, and would like to inform you that finally got the green card last week after 16 years in the country. Congratulations, that's great news. Now you can flip burgers or become the next Microsoft CEO.
A lot of people have got the green card they got their green cards in the last week, Emily, and they did not get the green card in their hand. Are the green cards going to be canceled because the prior date has backtracked?
So the online case status says it's approved recently.
That's right.
Yeah, so the good news there is as long as it's approved, even if you don't have your card in your hand, retrogression does not impact you. Your visa number has been assigned, so you're just waiting for the card, but that retrogression does not mean they're going to take it back.
Questions with related to those people. There are a lot of people who are asking questions. My date has been retrogressed. Will I still get the EAD and advance parole? Yes, the EAD and advance parole will still be processed. It will not have any hamper. You will still get the EAD and advance parole even if the priority date has backtracked.
Robbie has an interesting question. He has 2 EAD AP cards, one from 485 where he's the primary applicant and one from another 485 where he is the derivative. Does it matter which one I use for employment and travel?
That's a tough question.
Yeah, it could.
Especially
matter.
For the EAD, what if I just give both cards of EAD to the employer?
Well, if the employer is properly doing the I-9, they should not accept that, and they'll tell you need to pick which one.
Okay.
And so then I do think it matters because whichever one you pick will determine which 485 you're relying on, and if something goes wrong with that 485, it's not as easy to just go back to the other one. So yeah, definitely you should probably discuss with an attorney any issues in your case, in both cases, to make sure which one is the safer one to use at any given time.
Ananta has this question. If the I-140 has been approved, what are the chances of 485 getting denied? Very, 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 very rare. Unless you have some criminal history. I'll be very surprised for the 485s. It takes years for us to see one of the 485 denied. Especially for those people who have criminal history, now it's completely different now. When I say criminal, I'm not speaking about traffic violations, guys.
Enginelu says, my wife and my green cards got approved 10 days ago, but child's 485 is still pending. Priority date is 2012, EB3, which retrogressed in November. What are my options besides just waiting for EB3 to be current again? It's possible that even though your child's 485 has not been approved yet, they may have assigned an immigrant visa number to your child's case at the time when yours were assigned. So you may not have to wait. You may probably want to reach out to your congressman or senator's office for assistance with that and see if they can get things moving for your child so you don't have to wait and be in different statuses.
Fatima Babar has, what is the name? Name was updated, case status means. It could be anything. Sometimes when your case has been assigned to the officer, it tells it. Sometimes anybody touches the file, it may say name change, name was updated though. It doesn't mean that the name has been changed. But it most probably is when it's been assigned to an officer, that's what it says. Name was updated.
Yeah, that can be anything.
It could be also when
G28,
when we request a service request also, sometimes it says name has been updated. So it could be anything though. If you change the name, that's not what it says though.
Yeah, I don't think name was ever changed.
Anything but the name change. Anything and everything but the name change. Sushant has said, I came to US in 2017, but the I-94 shows travel back in India in 2018. How to correct this information? It's okay. If the I-94 site says a wrong date, it's not that controversial. Though we see that very often. You don't have to correct it. It won't have any negative impact on your immigration process. So sometimes they may get confused with your same name and the date of birth. There may be a lot of other people. It may crisscross those things, I wouldn't be that much worried about. And you will not have any problem, because nowadays everything is biometrics. When you are coming into the country, they're checking your biometric, you're the right person or not. So it should not cause any problem in your immigration.
Harry got an H4 and H4 EAD approved in June. That's valid till February 2024, and also recently got an H1 approved in August. I'm assuming that this was a change of status to H1, and wants to know, if I quit now, will I automatically move to H4, and can I use that H4 EAD? So if you quit now, you don't automatically revert back to the H4 status. You would be out of status. So you need to get back to H4 status. And you would either do that by filing a change of status to H4, or probably faster to do automatic revalidation, assuming you have your H4 approval notice that has a valid I-94. You go out to Mexico or Canada for less than 30 days, come right back in without going for visa stamping, show your H4 approval notice, you're immediately back in H4 status, and then can use that EAD that is not expired. But you don't automatically go back to your old status when you stop the new status.
Ramakrishna has this comment that he has seen the video of us in the IT serve. He thought very bad about us. Then he found out that the money we collected was actually went on to fight the USCIS on the H1B amendments and the H1B denials. And he see the victories in the court from the IT serve and the money we collected for the IT serve. We were part of the IT serve. I'm one of the founder of the IT serve. Yeah, thank you, Ramakrishna. We have some people that have misused that video when we are collecting the money, which we collected it, we rightfully used it for fighting it, for avoiding the H1B amendment, and also the denials, unreasonable denials of the H1B, which we were being successful in good number of cases. We're still fighting USCIS in the H4 EAD delay litigation, the class action also, that's done by our law firm. We're doing all those things. Yeah, that is a misinformation. Some of our opponents have put it on only to benefit themselves, and people have just taken it granted without looking into the details of what we do. Thank you for coming. Thanks for your comment, Ramakrishna.
Janinda has an H1B extension that was approved, but the H4 and EAD extension for a spouse are still pending. Wants to know, if the spouse travels before the H4 approval, what is the process to get the H4 stamped? Well, she would just use your approved H1B and get the H4 stamp based on that. She doesn't need the H4 extension to be approved at that point. But once she comes back in, she'll be given a new I-94, and you should send that into where the EAD is pending, so they can see that she has come back in H4 status. Because right now, 3 times this week, I've seen where the H4 application, the extension application, is denied by USCIS, saying that we see that you already traveled, got the visa stamp, and came back in, and you've already gotten your status extension that way. This serves no purpose, so we're going to deny it and close the case. They don't realize is, if there's a pending EAD along with it, what happens to that EAD? Will it automatically be denied? We've seen that happen in one case. So we try to proactively inform them that we still want the EAD to be processed to avoid that problem.
Saujanya has this question. Hey, what's going on this legal dreamers? What she's speaking about is the kids who came into this country under 18. Right now, Saujanya, the house provision has provisions for your child if they have entered into USA before they're 18. They have been residing in United States since that time. That means that before they turn 18. When they say reside, I mean a occasional travel to your home country doesn't interrupt that stay in United States. It allows them to apply for the 485 application. It allows them to apply for the 485 application. But we need to see if those provisions will come in the Senate bill. We wish that. I want you to write a letter to the senator to include those things. We have given a draft of it, but that provision of having your child to get the green card is there in the House. He should be able to file the adjustment of status if the House provisions are being passed, and the Senate has the same version of it.
Venkat says, I have EAD but no advance parole. If I travel outside the US, will it affect my pending 485? So if you are currently maintaining H1 L1, H4, or L2 status, and you go out, get that visa stamped, and come back, it will not impact your pending 485. But if you're in any other type of visa status or no longer in H or L status because you've used that EAD, if you then travel, you will abandon your 485. So you definitely have to have the advanced parole in that situation to travel.
Emily, with regards to the provisions of the new lottery system, there's nothing going on right now, is that right, Emily? And the H-1B lottery, based on the wage system, it's blocked out, and they're trying to issue new regulations. Doesn't look like, Krishna Kumar, that doesn't look like at this point of time that there will be any changes in the March or April of 2022. We could see at a later date, maybe in 2023, but doesn't look like it's going to happen in 2022 April quota.
Yeah.
1 second.
Question from YouTube. I filed my 485 along with my wife. My wife is not able to get the medicals yet. What happens if I submit my medicals? Can my wife continue on EAD until her medicals are submitted? So yeah, it's okay if you submit yours and she doesn't submit hers yet. Now, if she has an RFE asking for them, she needs to respond to the RFE within the deadline. But otherwise, if you are interfiling or you're filing right now and you're including your medicals but not hers, totally fine, and she can use her EAD.
Any chance of billing immigration bill to get approved from the parliamentarian? Naveen, it looks like this parliamentarian definitely is poised against us, though. She's been trained only to deport immigrants rather than help them out. That's my reading of her, though. I think so. We should just ignore the parliamentarian and then proceed. The Democrats should not hide behind the parliamentarian. The people voted for them because they promised us they are going to bring the immigration reform. They have the Senate in their hand. They have the House in their hand. They have the Senate in hand. So don't hide behind a person who has not been elected by the people. Don't hide behind her. It is your duty. You can ignore her and pass the bill. You have the majority, 50-50, and we have the vice president who's been elected by us. So you should pass the bill. That's our slogan to Democrats. So we have to keep the pressure on the Democrats to pass the bill with the immigration provisions.
Susanta came to the U.S. in 2017 and didn't travel, but in the I-94 website, it shows I traveled back to India in 2018. How do I correct this information? As far as I know, there's no way to correct it with CBP. So the only time you would need to correct it is if USCIS asks about it in an extension application or in your adjustment of status application, then you would document that you never left at that point. But I don't think there's a way to proactively correct it in that CBP system.
E2 visa pending for more than 12 months, is it normal? Definitely not. That's taking a longer time than normal. You should raise a service request, though. When is the Indian consulates are going to open for the B1, B2 visa, especially the Hyderabad consulate? We started seeing openings coming up, especially in the November 24th, 25th time. So you have to keep on logging on and keep on clicking, because there are a lot of people who are there who have been waiting for years now to get there. I know them. They spend 1 to 3 hours every day to see when the opening comes in. When the opening comes in, they book. So, but B1, B2, they will be coming in, but you just have to be very active in there.
SNH says, can we additionally do a non-specialized job with the 485 EAD? Yes, you can. You would not be maintaining your H-1B status at that point once you do that. But as long as you have the valid job offer to support the 485, you can do a second job in any kind of job without impacting your application.
Can I be a Uber driver, Emily?
Yeah, absolutely. Just don't do anything with marijuana. That's the one thing that you don't want to do.
Venkat has this question: is there a possibility to move from GCEAD to L1A? Absolutely, yes. If you have the L1A petition approved with the I-94, the best thing that you can do is that you can go to Mexico and come back. It's called automatic revalidation, though. When you come back, you just show them the L1A, I-797, I-94 approval. You come back L1A. If by any chance you don't have the I-797 with the I-94 approval L1A, though, then you may go to stamping to get the L1A stamped in your passport. That's the provision that's allowed. So people who get married to the adjustment of status, that doesn't mean that they cannot get divorced. They can. It's a lengthier process, unlike not getting married. But so you can. There are two processes. One is the automatic revalidation. One is going and getting the stamping of the L1 and coming back.
But he needs to have an advanced parole.
Yeah.
In order to not abandon.
Right. 485 application. Mm-hmm. That's right. Yeah.
Yep.
When does the H4 EAD premium processing coming? Definitely it's in the pipeline, but we cannot tell at this point of time when it's going to come, though. It is in the pipeline, but they're not addressing it right now.
All right. Prashant is also reporting that he got his green card after 10 years of being in the U.S. So congratulations, Prashant.
Anything else, Emily, before we close?
I think that's about it for today.
Thank you guys for tuning in.